Yes, 33.
Well, as item 33, Mellors, that based on record a sequence of relevant dates and events which was filed on 1st of April 25.
Yes, then
Your Lordships, before Lordships delve into the merits of the matter, I may only bring your Lordship's kind attention to a judgment of the coordinate bench of this Honourable Court, which has been passed with respect to the same advertisement on an eligibility criteria. It has been brought on record with the counter affidavit of the state. In my respectful submission, it would have an outright bearing on the matter, Your Lordship.
You mean to say the matter is covered by that order?
Your Lordship, there is a direction passed therein, which will have
where is that order?
With the counter affidavit of the state, Your Lordship.
Well, on page 22 of the counter, before my friend begins, if I may apprise, Mellors, I dealt with the minimum eligibility criteria to participate in the exam. And Mellors, there are specific paragraphs by the court.
Counter affidavit filed by respondent number 125.
Please, Your Lordship.
Page
number 22. Page number 23, if your Lordships may have it, in brief states the dispute involved in the matter.
Mellors, if my friend may read that because that's relevant.
I'm reading it for the benefit of everyone. Paragraph 3, I'm reading, Your Lordship. Page 23. The instant appeal arises out of judgment dated 2012-2023 of the High Court of Jharkhand at Ranchi, permitting the private respondents who were residents of Jharkhand and cleared the central teacher eligibility test or the neighboring state's teacher eligibility test to participate in the recruitment process for the post of assistant teacher in primary, upper primary schools in the state of Jharkhand in furtherance of advertisement 13 of 23. Your Lordship, this is the advertisement involved in the instant case as well before Your Lordships. The appellants have cleared the JTET and are challenging participation of private respondents. So, whether the clearing of the teacher eligibility test and the required eligibility wasn't involved in that case. Now, while considering this question, Your Lordships, if Your Lordships may kindly have page 61. And eventually the direction that is passed by this Honourable Court. Your Lordship, page 61, paragraph 57, I am reading. In the present case, undisputedly, the advertisement 13 was issued on 19/7/2023 and the eligibility criteria was set out as per 2022 recruitment rules, by which the candidates must have passed the teacher eligibility test conducted by the state of Jharkhand. On the date of pronouncement of the impugned judgment, those rules were in vogue, even when the High Court issued direction accepting the seated tested as eligibility contrary to the existing rule. After the impugned judgment, the examination was postponed until 10/2/24. If I may skip and come straight away to the fourth line from top, the amendment in 2022 recruitment rules were brought on 29/1/24 with the intent to give statutory backing for the changing eligibility in the ongoing recruitment process. This is the very same notification of 29/1/24 on which the petition is reliant.
So what is coming out from it?
Your Lordship, later the amendment in the advertisement was made. Thus, it is clear that on the date of the advertisement, as per the prevailing rules, the eligibility criteria were changed. In our considered opinion, this is amounting to changing the rules of the game after the game had become as settled in Tej Prakash Sonsam. Therefore, the entire action on the part of the state government is arbitrary. Reading the next paragraph, Your Lordships, at page number 63, just above paragraph 15.
What ultimately has been done?
I'm reading without expressing any opinion on the state's authority. Without expressing any opinion on the state's authority to promulgate the 2024 amended rules or its validity, we hold that the revised eligibility criteria introduced therein cannot be applied to the ongoing recruitment process initiated under advertisement 13. So, doing so would amount to altering the rules of the game after the recruitment process has begun. So, Your Lordships have taken the view that the 2024 amended rules would not apply to the ongoing recruitment process.
Yes.
And finally, at paragraph, page number 65 is the directions passed. Page 66 is the relevant Roman 2. The JTET holders who are possessing the requisite qualification under the 2022 recruitment rules prior to the 2024 amendment. And
so under the advertisement 13 of 23, only those persons who possess requisite qualification under the 2022 rules, they were eligible. And not under the amended rules.
Please, Your
That is all.
And we have been asked to publish the result. Now, results have been published under the 2022 recruitment rules.
As per the 22 rules.
It has been published. My friends here are relying on the 2024 amendment again with respect to this very same advertisement. I may also point out
Yes.
that contempt petitions were filed before the Honorable Court, and orders have been passed in that also. If I may just pass the order, pass in those.
So if I may point out what
Yes.
has not been pointed by my learned friend is, this matter, my lords, was dealt with respect to the eligibility criteria for participating in the exam. My lords may have a few paragraphs which was skipped by my friend.
No, what is your case?
My lords, my
See,
case is not a,
are you relying upon the 24 rules
my
with
lords,
respect to the advertisement of 13 of 20?
I bow down to that, my lords. My case is this. This case only dealt with the eligibility criteria. I possess that eligibility criteria, which is
No,
JTEC.
eligibility criteria according to which rules?
My lords, the original rules. Original rules prescribe
22. You are also
I'm also appearing in
All
one of
right.
the matters.
22 rules.
22 rules. I possess that eligibility criteria. In fact, para 62 is what my friend has skipped. My lords may read that. A categorical
Paragraph?
para 61 and 62, my lords.
No.
62 specifically.
Yes.
During pendency of these appeals, IA number so and so has been filed by the applicant seeking declaration that 2024 amended rules are ultra virus to the RTE Act. As per the discussions made here and above, we are not expressing any view in regard to the ultra virus of these amended rules, since they are not under challenge before the High Court or before this Honorable Court. However, our judgment would apply only with respect to the question posited to answer. Now, my lords, what was the question? I'll come to that, my lords. Paragraph 4, my lords, may have. The question was whether the candidates who do not possess the minimum eligibility criteria, which is Jharkhand Teachers Eligibility Test, could sit for this exam, which is not the issue here. Well, may have para 4.
No.
Well, here the issue is that para teachers who were working as Sahayak Adhyapaks, they were in-service candidates who were given a separate reservation under the rules.
So after 2016, no test was conducted,
Well,
Yeah.
and it was pursuant to the advertisement of 23.
Present case at all, my lords. This is just not the issue in the present case.
So we
We
hear
have-
you on merits then.
well,
Yes, this is, we have JTEC, which is the issue here. Now, the other issue is that we were already in service candidates, we were working. Because of our working, there was a specific 50% reservation of seats, which was done for us.
But you are the candidates who applied pursuant to the advertisement number
We
13.
applied pursuant to this advertisement, there's no doubt.
Now question is whether you are eligible or not.
My lords, we are eligible. We have the JTEC qualification. In accordance with this judgment, we crossed the goalpost here.
Then what is the issue then left?
There is 50% seats which are for category like us. There was previously a rule which said you will have to have 30% or 33% marks subsequently. There was an amendment that was brought by which only that particular aspect was taken away. Other than that, there would have been a merit list for these particular candidates and they would be appointed. Now, the challenge was done by a person before the High Court who did not even come within this category of para teachers for whom this 50% seats had been reserved. So, my lords, the issue is entirely different. The amendment had come much before the exams were held.
We understand the issue is
Nobody amongst us has challenged that particular provision because none of this category is affected by it. It's some third party who's not even in this who has challenged.
no. The issue in your case we understand is quite different.
Please, my lords.
They may not be covered by the judgment they are citing.
Please, my lord.
But we are asking you, you applied pursuant to the advertisement number 13.
Please, my lord.
You say you are eligible as per this judgment also.
As per this judgment, we are
also.
eligible.
You are
Yes.
eligible.
Yes.
Then what is the issue to be decided by us now?
My lords, the only issue that is to be decided is that so far as this 50% para teachers are concerned, the minimum qualifying marks were relaxed by an amendment. And that was done well before the exam. Now, nobody in this side of the para teachers has any objection to that. The objection is raised by a person who is not even qualified for this particular category.
If I may
So
only
the
assist
the
you,
minimum qualifying marks which were
And
relaxed for us
relaxed.
were correctly relaxed.
So the question is whether relaxation could be permitted or not.
Or not. And the certain findings of the High Court are actually contrary to the record and the facts of the case.
When that relaxation was introduced,
My lord,
Before the exam.
my lordship, 6 months before the exam, but undoubtedly
After the
advertisement.
advertisement.
But having said that, what is most important is when we talk about the level playing field, that nobody should be affected, you should not change what the rules of the
Yes,
game.
game.
My lords, the idea is that it impacts a group of people who would have otherwise been able to do that. Now, this group is that 50% para teachers. None of the para teachers have an objection to this. So, my lords, how is it said that it will affect anyone else?
No, but if you change the rules after the issuance of the advertisement, many people who may otherwise be eligible on account of this relaxation,
That will not
they may not have applied it.
question would not arise here.
Common.
My lords, that question will not arise.
That is the issue. The merit list.
No,
See,
no.
the vacancies
My lords,
are-
please hear the matter, my lords will realize that there is a distinction here. They are the
if I may just assist you,
The
Lordship.
vacancies in fact are.
No, we have understood. See, we have to hear the matter.
Your Lordship.
Hear the matter, my lord. Please.
Whether if you want to start today, we
My lord,
continue.
whatever is convenient to my lords, we are here and we are ready.
No, if both of you are able to finish it today, we can start. Otherwise, we fix a date.
We have to show the amendment. We have to show the
Okay,
amendments
okay.
and the-
No, today it may not be possible. Probably we have to rise a little earlier. There is
My
some
lords, just
function.
any day, but let it be little high on board so that we can be heard by my lords and we'll explain this whole thing. And my lords, the category on the other side
If I may
not
just
affected
assist on this point, Your Lordship, just a simple submission, Your Lordship. There is a clear direction from a coordinate bench of this honorable court that the selection process be held as per the eligibility criteria prescribed in the 2022
22 rules. Yes.
What
No,
do you-
22 rules, not amendment.
I'm sorry. I stand
22 rules.
2022 recruitment rules. In 2024 amendment comes about. My friend, the petitioners in this case are relying on a relaxation which has been given in the 2024 amendment rules, and that is why I cited
No.
coordinate bench judges.
That has not been touched by the.
No, whether relaxation has been provided by the 24 amended rules, then we have.
subject matter
My
of
lords, we have
concern by the other bench at all.
My lords, we have
My
questions.
You can't change the rules after the game has started.
So kindly allow me to explain that, and I will point out that my lords, the principle that the rules of the game cannot be changed once the game has begun is
We
only.
will hear both of you.
Please, my lords, I'm so.
Is there any urgency in the matter?
Yes,
The
yes.
recruitment process is going on, my lords. So next week sometime possible.
High on board, my lords, if it's possible next week.
Your Lordship, the contempt petitions which are pending vis-a-vis the other cases coming up after 10 days before the honorable, it was listed yesterday.
Point at this.
We are not concerned with it. Next week kar dijiye. Non miscellaneous next week.
And
My lords, high on board, if we may request, my lords.
We will see.